Hi, my name is Jeremy Davis. The case that I will be doing my presentation on comes from Chapter 3, Bearman versus the University of Notre Dame. Just a little brief summary about this case. You have Christina Bearman and her husband attended a Notre Dame football game. After the game, they were walking to their car. They noticed a fight taking place between two gentlemen. Both of the gentlemen were intoxicated. As a result, Christina Bearman was accidentally knocked down by one of those drunks, in which she suffered a broken leg. Now, Christina Bearman and her husband decided to sue the University of Notre Dame for damages done resulting in that injury. All right. Some of the focal points that we want to focus on in this case is the facts of the case, arguments from both sides, court's ruling, and what can we learn from this case. Before we get into the facts, we have some related cases that kind of help make judgment on this case, the first and the second time, actually. You have Corey versus Ray. Corey versus Ray really states that the operator of a place of public entertainment owes duty to keep the premises safe for its invitees. Um, this basically indicates that there is a duty to provide a safe and sustainable ingress, meaning entrance, and egress, meaning exiting, freedom to leave. Um, you also have a case where it's Verplane versus Commercial Bank of Crown Point, which stated that there's a duty to exercise ordinary and reasonable care to protect the patron from injury caused by third persons. In the last case, you have Hammond versus Algrete or Alligrete. I'm sorry if I pronounced that wrong. This case took place in 1974 that states, before liability may be imposed on the inviter, it must have actual or constructive knowledge of danger. Okay, so now let's move on to the facts of the case. The facts of the case is that we know Christina Bearman and her husband, James Bearman, were walking to their car after a Notre Dame football game when they noticed a fight taking place. The fight involved two men that were drunk. Christina suffered a broken leg when she was accidentally knocked down by one of those drunks. Christina and her husband sued the University of Notre Dame, holding them liable because she was invited as an invitee to the game. Some of the arguments of the case: the Bearmans argued that they were invited as business invitees of the University of Notre Dame. The only reason they were there is because Notre Dame invited them. The Bearmans also argued that Notre Dame owed a duty to protect her from injury caused by the acts of other persons on the premises. Notre Dame argues that there was no notice of knowledge of danger to a patron. The university could not be held liable for acts of third persons. The inviter is not the insurer of the invitee's safety. If they would, Notre Dame says that if they would have known of any harm, they would have made sure there was proper protection. Now, Notre Dame is aware that alcoholic beverages are consumed before, during, and after football games on their premises. Notre Dame is aware that parties are held in the parking area around the stadium. Notre Dame also is aware that tailgating takes place every home game on their premises. The court's findings. At first, the court found that Notre Dame was not held liable for the injury of Christina Bearman. But 5 years later, the Bearmans took the case to the Court of Appeals, and in which the case was overturned and Notre Dame was held liable uh, for the injury served because of the Reinstatement of Torts of 1965, which states a possessor of land who holds and open to the public for entry for his business purposes is subject to liability to members of the public while they are upon the land for such purposes, for physical harm caused by the accidental, negligent, or intentional harm of acts by third persons or animals, by the failure of the possessor to exercise reasonable care to A, discover that such acts are being done or are likely to be done, or B, give a warning adequate to enable the visitors to avoid the harm, or otherwise to protect them against it. B, also two other reasons why the case was overturned and Notre Dame was held liable, because Notre Dame had reason to believe that people would have alcohol intake and some become intoxicated, which posed a threat to the safety of patrons. Last, therefore, Notre Dame is under a duty to take reasonable precautions to protect those who attend games from injury caused by third persons. Now, what can we learn from this case? Uh, we learned that Notre Dame did not take proper precautions for the event that took place. Notre Dame should have had proper security measures set in place to prevent incidents like this. Notre Dame is if Notre Dame is going to invite someone to the athletic event, then they should have a special parking area with security supervision for their business invitees. Uh, Also, Notre Dame should also warn people attending their athletic events on their premises with proper signs and or around the parking and stadium areas to notify people that tailgating and tailgating parties takes place before, during, and after games. Notre Dame uh, should also have security on duty in the parking lot area as well as around the stadium uh, to help prevent certain things like this happening where they won't be sued. Okay, well, that concludes my presentation. I hope you enjoyed it. Thank you.